Good afternoon, everyone. For those of you who don't know me, I am Lanisha Lightborn, the Business Development Manager for Asset Management and High Net Worth Services at the Bermuda Business Development Agency, also known as BDA. The BDA is an independent public-private partnership, and our focus is on inward promoting the jurisdiction and encouraging inward direct investment. We have teamed up with Step Bermuda for a series of webinars which have run through February, and we hope to continue for the upcoming months. Today, we bring together one of the leading experts in his field to discuss the amendments of Bermuda's Firewall Legislation and the Children's Act. Thank you again for joining us today, and please log on to the BDA website for any additional updates and for recordings of this webinar. I would like to hand it over to the chairman of the Bermuda Step. I have lost my words. I'm human. I'd like to hand it over to Ashley Fife, the chairman of Step Bermuda. Thank you.
Yes, the Society of Trust and Estate Practitioners. We're delighted to be partnering with Business Bermuda Development Agency with these presentations. And as Lanisha mentioned, we really have, we're fortunate to have Andrew Holden, barrister at 24 Old Buildings, join us today to present to us. I think it's only fair, someone who takes the time to present to us deserves a plug. So I thought I'd give Andrew a bit more of a plug. Not only was he involved, as was David Brownbill QC, in the drafting of these amendments to our firewall legislation, he was also involved in the amendments to the Trustee Act in 2014, where we introduced Section 47A, aka Statutory Hastings-Bass. He's written a fantastic book on trust protectors, which is very well regarded. He has some amazing accolades from Chambers and Partners. I'll just mention one of them, which I think is enough. Best of his generation. Fantastic. He's been involved in a number of high-profile trust and also commercial cases around the world and in Bermuda, including the Dawson, the piece of the Dawson-Damer litigation here. Last time Andrew presented to us on firewall legislation was before these changes. And I remember the presentation had quite a racy title, Great Walls of Fire. Today, Andrew's gone for a little more reserved title, but I'm sure that the presentation will be just as racy and not to mention highly informative. Over to you, Andrew.
Thank you, Ashley. I hope it will be informative, if not inflammatory, although with the subject matter, fire is not too far away from the topic, is it? Yes, so today I'm presenting on what I call the 2020 trust law reforms in Bermuda, which are the two pieces of legislation which I hope were provided with the pack that is accompanying this seminar, namely the Trust Special Provisions Amendment Act 2020, which is the firewall legislation, the modifications and improvements introduced there, and the Trust Special Provisions Amendment Number 2 Act 2020, which is the amendment to the Children's Act. As Ashley says, I was involved in the preparation of the firewall legislation, and he may also recall that we had some discussions on the amendment to the Children Act as well, which has been a long-running a project which has been brought to fruition in 2020. And certainly from my point of view, I view these amendments to the trust legislation in Bermuda as being distinct improvements, as being pieces of legislation that clarify and, as we'll come on to see, I hope, improve and facilitate certain aspects of the administration of trusts in Bermuda, and which, again, place Bermuda at the cutting edge of the international trust industry, really, because they are amendments which I think take some of the concepts that we're dealing with here, in particular the firewall concept, further than any other jurisdiction has taken the concept to date in terms of streamlining it and making it work in a practical way for trust practitioners and for clients using Bermuda structures. So with that, I'll begin my presentation with just a sort of look back over where we've gotten to in terms of the amendment of and improvement of Bermuda's trust law in the last few years. As most participants in this seminar will know, there has been a major push in the last, sorry. I've lost that slide. I don't know, Corinne, if I can go back. Well, I can tell you, there we are. I can tell you about it anyway. The major push in the last few years for the improvement and streamlining of Bermuda's trust law. The initiative has been spearheaded by the Trust Law Reform Committee of the BBDA. It's been supported by STEP Bermuda, and it has manifested itself in a number of major improvements to Bermuda's trust law. Probably in the last decade, I would say, we can identify regular instances of statutory reform that have improved the law, starting with the perpetuities and accumulations legislation back in 2009, which was then taken further in 2015. The net effect of that legislation being to abolish perpetuity periods for future Bermuda settlements, and also to enable a very interesting and innovative jurisdiction to disapply the perpetuity period to existing Bermuda settlements. And that has been, I think, very well received by the industry. And I know there have been a number of decisions reported on that, which has been of great use to clients in Bermuda. That was then followed by the Settle or Reserve Powers legislation in 2014, which I think is still at the forefront of any trust jurisdiction in terms of the manner in which it enables settlors of Bermuda trusts to reserve powers to themselves or to confer those powers on third parties such as protectors. As Ashley mentioned, the statutory Hastings-Bass legislation in which I was involved also in 2014, which again has been used on a number of occasions to deal with certain issues in Bermuda trusts, and I think has been well received. And then the latest round of statutory improvement, which I'm going to be talking about today, the Firewall Legislation and the improvements to freedom of disposition by the amendment to the Children's Act. So we start with the Firewall Legislation, and that has been modified and improved by the Trust Special Provisions Amendment Act, which is an amendment to the main the main act being the Trust Special Provisions Act 1989. The law was brought into force on the 5th of August of last year, and on the terms of the legislation, it applies to all matters, including all proceedings currently on foot, and makes modifications both to the jurisdiction of the court and to the way that the Bermuda Firewall operates. So what I'm going to do in this talk is try to give a commentary on the various amendments that the 2020 Act has made to the jurisdictional provisions of the 1989 Act. I'm afraid it does get a bit involved because we are dealing with some complex questions of private international law. But what I want to focus on in particular in this seminar is some of the practical ramifications of the legislation and how it will impact on trust administration in Bermuda and on the sort of business that we all do on a day-to-day basis. So starting with the, with the, what you might call the definitional section of the Act, part of the clarification process that is undertaken by this amendment to the 1989 Act is to introduce a series of new defined terms into the trust legislation, which are then used throughout the legislation to define the scope of the court's jurisdiction and the way that the firewall will operate. And really the centerpiece of that is this new statutory definition of a Bermuda trust. So for the first time in Bermuda trust law, we define what a Bermuda trust is. And it is a trust that is governed in whole or in part by the law of Bermuda. Now that mirrors some of the legislation of other international trust jurisdictions, with one exception, that Bermuda law introduces the idea that a Bermuda trust is one governed in part by Bermuda law. And so what that means is that where a trust is governed by different laws and severable aspects of the way that a trust operates is governed by different laws, if Bermuda law governs one of those aspects, for example, Bermuda law is said in the deed to govern the validity of the trust, then that is a Bermuda trust for the purposes of this legislation. And that is, I would say, more expansive than the law of other jurisdictions. And what it does is it brings any trust governed by Bermuda law in any part into the jurisdictional regime in this section. And then in the interpretation clause, that is then defined, Bermuda trust is defined as against other trusts, foreign trusts, which are trusts other than a Bermuda trust. And the interpretation section also defines foreign courts, foreign laws, and foreign orders. And as we'll see, those definitions are then picked up in the jurisdictional sections of the Act. So we then move on to Section 9, new Section 9 of the 1989 Act, which has always governed jurisdiction, but the new wording replaces in its entirety the old wording of Section 9. And we have two major changes that you need to be aware of in relation to this section. The purpose of Section 9 of the 1989 Act is to define the circumstances in which the Bermuda court takes jurisdiction in respect of Bermuda trusts. And the previous legislation prior to the 2020 amendment did that in a simple way. Maybe you would say oversimple. It simply said that the Supreme Court has jurisdiction to determine cases where one or more of certain criteria apply, namely where the trust was governed by the law of Bermuda, where a trustee was located in Bermuda, where the administration of the trust happened in Bermuda, or where the trust assets were in Bermuda. That list remains in the new law, with one addition which I've underlined on your slide, which is that list also now includes where the trust instrument includes a jurisdiction clause in favor of the courts of Bermuda. Now, that's something that when the 1989 Act was initially enacted was perhaps not so common in trusts, but these days, virtually all trusts, certainly new trusts coming into creation, include jurisdiction clauses in favor of one or other court system. And it's therefore appropriate that where the trust deed itself gives jurisdiction to the courts of Bermuda to determine matters involving the trust, that the Bermuda court will have jurisdiction to determine that dispute. And so that has been, you might say, that lacuna which existed before has been filled by the 2020 law. But probably by far the more important change made to Section 9 by the new legislation is the insertion of the words at Section 9.3 of the Act. And you'll see them there on the slide. They are, I'll just read them. The jurisdiction of the Supreme Court is applicable as provided under this section, notwithstanding that the person against whom the claim is made is not in Bermuda, or, where applicable, that any wrongful act, neglect, or default giving rise to the claim did not take place within its jurisdiction. So in other words, the Bermuda court has jurisdiction even where the person who is the defendant to the proceedings isn't in Bermuda, or where the thing being complained about didn't take place in Bermuda. Now, the words at Section 9.3, which are now obviously in the 1989 Act, are chosen with particular care. And they are chosen in order to mirror the wording of Order 11, Rule 1.2 of the Rules of Supreme Court of Bermuda. And they mirror the words of the rules of the Supreme Court in that section for a very good reason, which is that that section of the rules of the Supreme Court says in terms that in these circumstances, there is no need for the plaintiff to obtain permission to serve proceedings out of the jurisdiction. And so proceedings can be served extraterritorially on defendants outside of Bermuda without any need to go to court and obtain the court's permission to do so. And so by mirroring that wording in the Trusts Act, practitioners now have the ability to serve trust proceedings on parties out of the jurisdiction without getting the court's permission. And that is a major practical improvement over the old law. And it is also a practical improvement over the way that jurisdiction is dealt with in the laws of other trust jurisdictions. Because most other trust jurisdictions continue to have the same format as the old Bermuda legislation, namely to stipulate that their local courts have jurisdiction over their local trusts, but not to spell out what that means in practice. And so I think it's right to say that Bermuda is the first jurisdiction giving the ability to serve trust proceedings out of the jurisdiction without the need to get the court's permission. And that has a major practical effect, of course, because certainly in cases which are contentious, it is useful to be able to seize the court of jurisdiction without the need to obtain permission. And even in cases which are non-contentious and relate to the administration of the trust, it's often highly inconvenient to have to obtain permission to serve the sort of parties to Bermuda trusts who, as we'll know from experience, can live anywhere around the world, and serving them can often be an inconvenient hurdle to the start of administration proceedings. That's all dispensed with under the new Section 9 of the Trusts Act. So we move on then to the firewall provisions, which are new sections 10 and 11 of the 1989 Act, inserted obviously by the 2020 Act. And really these are broken down into two sections. Section 10, which is what I've called the choice of law rules, which will govern trust matters. And then section 11, which is the firewall, properly so called, and we'll come on to talk about what that means. So starting with the choice of law rules, new section 10 of the 1989 Act. Now, what you need to understand to make sense of these choice of law rules is what they are replacing. And what they are replacing in the old 1989 Act, and which is actually the model used in other trust jurisdictions, is, as far as I'm concerned, convoluted, confusing, difficult to apply in practice, and really something that for practitioners looking for practical, as it were, guidance about how these pieces of legislation are supposed to apply, really something that was not satisfactory at all. What I've described as being the old model, which actually I suppose in other jurisdictions should be called the current model, is a carve-out of a carve-out of a carve-out. And I need to explain that and just unpack that for you. The choice of law rules are all about when Bermuda law will apply as opposed to when foreign law will apply. And what they are designed to do is apply Bermuda law to the questions of trust administration, which the Bermuda legislature wants Bermuda law to apply to. But under the old model, that happened in this convoluted way. What happened was that the legislation provided that all foreign law would be excluded. So only Bermuda law would apply to any question involving a Bermuda trust. Then it said, but some foreign law will continue to apply to Bermuda trusts, just a subset of the foreign law, but then a subset of that subset would then have Bermuda law reapplied to it. So it was a bit like Russian dolls. Bermuda law, but then you look inside that and you would have some foreign law applying, but then you would look inside that and then Bermuda law would apply all over again. So very confusing, and it made it difficult to know which law you were supposed to be applying at all. That's been done away with under the new model. And the new model replaces that old system with what I hope is a much more understandable and easy to follow set of choice of law rules about when Bermuda law will apply to a Bermuda trust. And you can think of it in this way. Bermuda law applies to certain questions relating to the creation or settlement of the trust. And so the starting point is that when you're within these policy areas, these three policy areas that I'll come on to, Bermuda law is going to apply to questions relating to the settlement of the trust. If you're not in those three policy areas, then ordinary choice of law rules will apply. And what that means is, if foreign law would have applied otherwise, then foreign law is going to apply. If Bermuda law would have applied otherwise, then Bermuda law is going to apply. So before we come on to those policy areas, let me just give you an example. Say you've got a question over whether the settlor of the trust had capacity to settle the trust, and the settlor is domiciled in the UK. Then if you're dealing with these three policy areas, which we'll come on to, Bermuda law is going to apply to that question. If you're not dealing with those three policy areas, then ordinary choice of law rules will apply. And ordinarily, a person's capacity is dealt with by the law of his domicile. And so in that example, UK law would apply. Or take the question of whether a person owned shares. If the three policy exceptions, three policy areas apply, Bermuda law will be applied under these choice of law rules. If those three policy areas don't apply, then the ordinary conflict of laws rules would apply. And again, normally, the question of the validity of a share transfer will be governed by the law of the incorporation of the company. Now, that is all about the settlement of the trust. Once the trust has been validly settled and property has been validly transferred to the Bermuda Trust, then the other aspect of these choice of law rules is that the operation of the trust, virtually all questions relating to the operation of the trust are going to be governed by Bermuda law. So let's just go over that one more time. You have these three policy areas relating to the settlement of a trust. Questions like the capacity of the settlor, the ownership of the property, the validity of the transfer onto the trust. Where those three policy areas are engaged, Bermuda law will apply. Where those three policy areas are not engaged, then the ordinary choice of law rules are going to apply to questions of settlement of the trust. Once your trust is up and running, questions relating to the operation of the trust are, with very few exceptions, going to be governed by Bermuda law. So that is the new scheme for the choice of law rules. Rather than the Russian doll approach, it's simply some laws about policy chosen by policy, which will always apply Bermuda law, and then otherwise the settlement of the trust will be governed by the usual conflict of law rules. The operation of the trust will be governed by Bermuda law. And so if I move on to the three policy areas that I spoke of, these are the three areas where Bermuda has, as a matter of policy, chosen to apply its own laws in circumstances relating to the creation and valid settlement of Bermuda trusts. And they are forced heirship, divorce, and insolvency. And so running through those briefly, forced heirship, of course, is a rule of foreign law that will override the freedom of the settlor to dispose of his or her property in the way he or she thinks fit. And it has always been the case that the public policy of Bermuda is that freedom of testamentary disposition should take precedence. And so where a person asserts that a trust in Bermuda was not validly created or should be set aside, or property was not validly transferred to it because he or she has a right as the settlor's heir under a foreign law, that rule will be disapplied in Bermuda in favor of the Bermuda law governing the validity of the creation of that settlement. The second policy area is divorce or relationship breakdown. And again, the policy here is that it is the public policy of Bermuda that a person should be entitled to create a Bermuda trust and settle property on it, and not to have that trust reversed or varied or set aside, or the disposition of property onto that trust questioned in later divorce proceedings, where the Bermuda court itself would not intervene to provide rights in respect of that divorce. And then the third policy area, which you might say is the most interesting, if not controversial, of the three, although I'll explain why I think it's legitimate, is insolvency claims overseas. And again, it has always been the public policy of Bermuda that claims arising out of a foreign insolvency should not govern the disposition of property onto Bermuda trusts, and that should be governed by Bermuda law. And Bermuda law in this instance also includes, importantly, Bermuda remedies for creditors and others affected by an insolvency process. Bermuda has always had provisions which allow dispositions to be set aside where there is a subsequent insolvency, so-called clawback remedies under the Statute of Elizabeth or subsequently under the Conveyancing Act in Bermuda. And the Bermuda legislature has taken the decision that those remedies should be available to creditors, both in Bermuda and overseas. And it should not be permissible for greater remedies to be available simply because a foreign insolvency process is underway. And so there are the three areas of policy, of public policy of the islands, where the choice of law rules in the 1989 Act will be applied to all questions involving Bermuda trusts, both in terms of their valid creation and in terms of their operation. Now, there can be a debate about whether those are valid areas of public policy, how that public policy interacts with the public policy of other jurisdictions, but those are conscious policy choices that have been taken by Bermuda's Parliament, and they will apply to protect the integrity of Bermuda trusts in all circumstances involving those areas. But then importantly, once one steps outside of those areas, Bermuda will apply the normal choice of law rules to the question of the creation of trusts. And sometimes, there is a pejorative attack on this kind of firewall legislation as being the fraudster's charter or the thieves' charter. It is not that at all, because Bermuda will apply the normal choice of law rules outside of those three policy areas. And so, for example, where one is dealing with title to property, ownership, ability to create a Bermuda trust and to dispose of property onto trust, that is going to be governed in the usual way by the appropriate law as chosen by either the foreign court or by the Bermuda court. And if it's foreign law, then it will be foreign law. Bermuda's not trying with this legislation to overturn property rights created by foreign law that are outside of those specific policy areas where the Bermuda court has, Bermuda legislature has chosen to intervene. So this is absolutely not the charter for persons trying to create trusts of property that they don't own. It just simply can't be used in that way at all. What this legislation does do, though, is it provides a shield to Bermuda trusts once they are created, so that foreign courts are not going to intervene in the administration of a Bermuda trust. by applying foreign law that the Bermuda court would not permit to be applied. There are two limited exceptions to that. One is in relation to foreign land, and it's always been the case that the Bermuda court will defer to foreign law in relation to the question of how foreign land is dealt with, and that will continue to apply under the new model. And also, where part of a Bermuda trust is governed by a foreign law, then of course, the foreign law will be given precedence in relation to that severable part. But other than those very limited exceptions, this choice of law regime is designed to provide a shield that once the trust is created, once the property is validly settled, once we are satisfied that all of those formalities were done appropriately to create the trust, then its subsequent operation is going to be subject to Bermuda law. We then turn to the firewall provision, properly so called, and that is Section 11 of the 1989 Act. It's pretty straightforward. It applies to all foreign orders, including foreign arbitral awards. So anything a foreign court or tribunal has done purporting to, affect a Bermuda trust. And the firewall itself is very simple. It says that if a foreign order, including a foreign arbitral award, is inconsistent with Section 10, so inconsistent with the choice of law rules for trusts in Bermuda, then the Bermuda court will not give effect to that order, just won't give effect to it. And as you'll see, I've put on my screen the nature of what not giving effect means. It's very broad. It won't give effect directly or indirectly to that order, won't confer any right, won't impose any obligation or liability, won't raise any estoppel. That order is simply shut out in its entirety from operation in Bermuda. So that gives rise to the practical question of when foreign orders will be given effect in relation to Bermuda trusts. And we can look at the operation of the choice of law rules and the firewall in that context. So when you've got a foreign order which is purporting to affect a Bermuda trust, there are a couple of questions that are going to be asked. First, does the issue which the foreign court has purported to determine fall within the scope of the choice of law rules which apply Bermuda law to that question? And if it does, and if the foreign court has purported to apply a foreign law to those questions, then the firewall is going to shut out that order from having any impact on the Bermuda trustee in Bermuda. By contrast, if what the foreign court has purported to do is outside of the choice of law rules, in the sense that those choice of law rules would have applied that foreign law as well, then the firewall is not going to keep out that order. So what you're going to need to be looking at is whether there is a challenge to the settlement of the trust in particular, other than on the basis of a foreign law which is excluded in accordance with those policy considerations. And I've given you a couple of examples of when a foreign order might be permissible under these choice of law rules. For example, where it's applying to the ownership of foreign property, where these three policy areas don't apply, and where the ordinary choice of law rules in Bermuda would apply that foreign law. But the other interesting question is whether if the foreign court has applied Bermuda law, whether the firewall will allow that foreign order to apply in Bermuda. And I think that's a question that Ashley and I might discuss at the end of this presentation, but I think perhaps in summary, it's not enough to say that the foreign order has applied Bermuda law. The question is going to be whether it's applied Bermuda law correctly. Now, beyond that, there is going to be the practical question of the Bermuda court wanting to give effect to orders of a foreign court where it might have done the same thing out of comity with that foreign court. In other words, it respects the foreign court, it respects what it has done, and it may wish to give effect to what the foreign court has done. But really, under this firewall legislation, that is very difficult for the Bermuda court to do, other than by starting afresh and applying Bermuda law to the question and potentially reaching the same result. The firewall is all about making sure that Bermuda law applies. And so long as the court goes through the process of applying Bermuda law, then it may be possible for the court to give effect to foreign orders in that indirect fashion. But that really does mean starting from scratch and applying the Bermuda law, not giving effect to the foreign law by the back door. And as I've said, there is this absolute prohibition on importing foreign orders affecting Bermuda trusts, other than in these limited circumstances. In my view, this legislation is as robust and as extensive as firewall legislation can be. The policy exceptions have been clearly set out. And if a foreign order is purporting to trespass in those policy areas or in the operation of a Bermuda trust, then it is going to be extremely difficult for the for anyone, for the plaintiff, or indeed for the court, if it is even sympathetic with the foreign order, to give effect to that foreign law. And this is going to mandate the court and all litigants to apply Bermuda law to these questions. But of course, we have enterprising practitioners such as Mr. Fife and myself, who will be looking for ways around this, and no doubt these provisions will be tested in court before too long. And so I've summarized the practical consequences of the jurisdictional firewall provisions of the 2020 Act there. In the interest of time, I'll move on, because I think I've dealt with those provisions, but I do think that this firewall provides the strongest possible protection for Bermuda trusts and for Bermuda trustees against foreign orders that would seek to undermine the integrity of those trusts. Now, I'm going to touch briefly on the other piece of legislation that Bermuda passed last year, which is dealing with freedom of disposition in relation to Bermuda trusts. And it's the Special Amendment, sorry, the Special Provisions Amendment number 2 Act, which amends the Children Act and which received royal assent on the same day. Now, this is a very simple amendment which corrects what I would say is an anomaly that previously existed in Bermuda law. The old position was under the Children Amendment Act 2002, which introduced sections 18A and 18B of the Children Act, which provided, in summary, that for all purposes of the law of Bermuda, a person who is the natural child of his parents is going to be treated as having that status independently of whether that child is born inside or outside of marriage. So in other words, this abolished, for all purposes of Bermuda law, the distinction between legitimate and illegitimate children. And it did so not just for legislation, for government action, but also for private instruments such as trust deeds. And that meant that following the passage of that act, it was literally impossible for a settlor of a Bermuda trust to exclude illegitimate children or issue from the class of beneficiaries of a trust in Bermuda. And I say almost impossible on the slide. It was possible to name only legitimate children by name, but in terms of creating a trust for the benefit only of legitimate children in issue, that was impossible in Bermuda. It was almost a unique restriction. I think only one other jurisdiction I know of had this restriction on private dispositions by settlors. That was the Canadian province of Prince Edward Island. None of the UK, the USA, Australia, New Zealand, any of the other trust jurisdictions, which are Bermuda's competitors, had any such restriction in their laws. As I say, I know of only one other jurisdiction anywhere in the world that had this restriction. And I thought it was inappropriate and think that it was an inappropriate restriction. I believe that freedom of disposition is an important right. And if a person wishes to create a private trust for legitimate children for all sorts of reasons, that may be a legitimate thing to do, and that having an absolute prohibition on that right was not appropriate. There is a specific religious issue here because in certain religions, in particular in Islam, there are different inheritance rights for legitimate and illegitimate children. I certainly don't purport to judge that. And Muslim settlors are perfectly entitled to impose Sharia law provisions in trusts which they create, which of course make provision for all children, whether legitimate or illegitimate, in accordance with the rules of that religion, but do so in different ways. And it was about the variation and the different ways that children have to be looked after under that religious code, which simply couldn't have been given effect by a Bermuda trust. And that, as I say in the slide, shut off Bermuda from important parts of the international trusts market for no good reason that I could see. And it's not the public policy of Bermuda, so far as I'm aware, to restrict private individuals exercising their freedom of disposition in accordance with their own religion or with other considerations such as privacy or making separate provision for different parts of a family. And I could see no good reason for it. It has now been abolished by the new Act, which introduces a very simple provision that if a trust instrument expressly states a contrary intention, then this restriction will be disapplied. And this restriction is made subject to that rule. And so from here on in, if a contrary intention is expressed in a Bermuda trust, then a Bermuda trust will be capable of being set up for a class of legitimate children or issue only. The default position in Bermuda will remain that all issue of a settlor is included, whether legitimate or illegitimate, and this will be an opt-out provision for settlors who, for various reasons, including these religious reasons, wish to make that exception. But this law will apply to all Bermuda trusts whenever created. So any Bermuda trust that was previously created for the class of legitimate children only, I think will now be read in accordance with the express terms of that trust instrument. Any trusts which have been created which don't have an explicit opt-out, then there will have to be a conversation with clients about whether that ought to be introduced by way of variation. It won't apply automatically because this is an express opt-out regime. But for all new trusts going forward, it will be possible to create trusts in accordance with client wishes, where this is a factor. And this, as I say, unique restriction on freedom of disposition in Bermuda versus all other onshore and offshore jurisdictions, bar one, has now been removed. And so we have a lot more freedom now to create trusts in accordance with our clients' wishes, if that's what is required. And so, as I say on my summary slide, which I have again preempted, apologies, Bermuda is now on a par with all other major jurisdictions, both onshore and offshore in the trust world. And I hope that this increases Bermuda's competitiveness whilst simultaneously removing what I always viewed as an unprincipled anomaly in the previous law. I'm going to touch very briefly, I'm conscious of the time, on future trust law reform. I think there are possibilities for the conveyor belt to continue of trust law improvements in Bermuda. I know that the BBDA is very interested in that, as is Step Bermuda. There is the possibility of following other trust jurisdictions on areas such as trust arbitration, the creation of private law foundations, and following what Jersey and Guernsey have done in terms of limiting trustee liability to the trust fund. If that were to be followed, what I would be looking for is what I think Bermuda has done previously with trust law reform, which is best in class legislation. And I think Cayman recently paid Bermuda a compliment of copying, I'll use that word, I could use more derogatory words, the statutory Hastings-Bass legislation almost word for word, which I think is, what do they say, imitation is the best form of flattery. And I also think that in terms of best in class legislation, there are things Bermuda can do which will lead the way in a way that no other trust jurisdiction has done. I think we've seen elements of that in the firewall legislation, but I think there are other areas where Bermuda can really lead the way with very innovative statutory reform. And I think you're fortunate to have an industry body in the BBDA and a government which is very receptive to that. And I think it's a sort of watch this space for that sort of further reform. That's all I wanted to say. I think I've taken up more of my time than I was supposed to, Ashley. So I'm sorry if I was cutting you off from asking me difficult questions. I hope that's not the case. If I've stopped you asking the most difficult, start with the easiest and we'll go from there. And if we run out of time, it's just too late.
I think that you addressed the more complex questions I had earlier. But an interesting question has come in. You may be aware of the Cayman Stingray case.
Yes, absolutely.
And the question is whether you think the result in that case may have been different under Bermuda's new firewall legislation.
I think possibly it would be, yes. Stingray is quite a complex, I mean, all of these cases on firewall are quite complex. The other interesting thing, of course, about Stingray, I think, is that it was a decision of Mr. Justice Kawley, who is now sitting in the court in the Cayman Islands, but was, of course, the former Chief Justice of Bermuda, wasn't he? So, Stingray, as far as I understand it, was all about, and it's actually a very recent case, I think it was only handed down a couple of weeks ago in Cayman, but it was all about the creation of the valid creation of a trust and capacity to settle the trust. And it was a case about staying proceedings on the grounds of forum non-conveniens. Now, the question really in the case, which is interesting, is whether the parties to the case were really pursuing a forced heirship remedy or not, because the case in, I think, is it Italy? Correct me if I'm wrong.
I think that's right.
I'm not sure who asked this question, but I think it was in Italy. And I think standing behind the challenge was the were the legitimate heirs. Now, a question will be whether what was happening in Stingray was an attempt effectively to put into effect forced heirship, a forced heirship claim by the back door. And what I would say about the new Bermuda regime is that the wording of the firewall is very robust. The choice of law regime sets out a series of well, I can read it to you in the time available rather than paraphrasing it. A foreign law is excluded if it creates, recognizes, or defeats, or gives a foreign court power to create, recognize, or defeat any right or interest in or to property, or any obligation or liability on any person by virtue or in consequence or in anticipation of the death of a person other than as a result of a voluntary disposition. So it is very broad. It covers all manner of claims and means of formulating a claim. Now, and it will apply Bermuda law to any of those. Now, the key question in the case, therefore, is going to be, is this a sort of case about title? Is it a case about settlor capacity in a sense which is outside of that policy? Or is this really an attempt to get round the forced heirship policy by the back door? Now, I can't say I'm sufficiently familiar with the facts of the case to give an answer to that. So apologies to whoever asked that question. But what I would say is the Bermuda law is very robustly worded in terms of the scope of issues that it will cover when we are in that policy exception of forced heirship. So I hope that goes some way to answering it. Probably not on the forum non-conveniens side of things, but that's on the sort of difficult side of things where I'm hoping we're starting to run out of time.
I promised that I'd ask a question about what you called the old chestnut of the Colonial Laws Invalidity Act.
Oh, and gosh, yes.
Whether that, because arguably the firewall legislation may be inconsistent with that and therefore invalid. What are your thoughts on that?
Well, again, a big area, but I have never been in the school of thought that the Colonial Laws Act has any impact on this sort of regime. As far as I understand the argument, it's that the Colonial Laws Validity Act overrides the legislation of Bermuda because Bermuda is a colony. Now, that sounds wrong on its face. I think there's also a good reason why it's wrong, namely that Bermuda was given a constitution by primary legislation in England back in, I think it was in the 1960s, wasn't it? And then updated by instrument in 2002. So I would say that the primary legislation in the UK that overrides that status in the Colonial Laws Validity Act, because it is giving internal self-determination to Bermuda. Now that has to be done by way of implicit revocation, but it seems to me that was what was intended. When Bermuda was given a constitution and it was given the right to pass its own laws, that wasn't subject to someone turning up 50 years later and saying, oh, and by the way, you're a colony, so here's a UK judgment which I'm going to bring in under some UK legislation. So personally, I think the Bermuda court would have short shrift with that, as would the English court, I hope. But I think, correct me if I'm wrong, it's yet to be tested. Maybe because people haven't been courageous enough to go through the hoops of testing it. Is that right?
Well, it certainly hasn't been tested in Bermuda, but I think there may have been some well-known discussions in a Cayman case that perhaps settled, and ultimately the argument wasn't run.
Okay, well, hasn't made its way to the Privy Council yet, but I'm not sure I'd be the one wanting to stand up and make that argument if it ever makes its way that far.
And
although, having said that, if you do want to instruct me to that effect, then by all means.
Okay, absolutely. So just wanted you to perhaps outline the relationship between the fraudulent transfer provisions in the Conveyancing Act here in Bermuda with the firewall provisions.
Sure. The fraudulent transfers legislation is part of the law of Bermuda. And so when the domestic law of Bermuda applies, even in these policy cases, it will include the fraudulent conveyances legislation as part of the domestic law. So for example, if a foreign creditor of a foreign insolvency process wants to come to Bermuda and say, please set aside this disposition, and it meets the test in the fraudulent dispositions law, then that will be acceptable. And that will not be something that is excluded by the firewall. And so, again, you can see how this is perfectly consistent with Bermuda policy. If a foreign creditor wants to come to Bermuda and argue and meet the test Bermuda has set for setting aside a disposition, and let's be honest, this is not an outrageous test which is set in the Bermuda fraudulent dispositions law, is it? It's a sensible clawback regime where transactions are entered into in fraud of creditors. If you can meet that test, then you're going to be able to set aside the disposition. What you're not going to be able to do is go and use a foreign insolvency process to set aside transfers into a Bermuda trust and then circumvent the Bermuda test for when a conveyance will be set aside.
Thank you. And I think the previous legislation dealt with perhaps dispositions by companies and through foreign wills more explicitly than the current legislation. But I suspect that those matters that perhaps fall outside of those policy areas, and therefore
and that's one of that's right. And I think that's one of the I hope one of the attractions of the law, that the reason those provisions were necessary is because of that Russian dolls approach I was talking about. That when you say all foreign law is excluded as your first point, then that can't be right. And so you have to bring in all manner of exceptions to that exception in order to reset the balance. By restructuring the law and having it apply only in these specific policy areas, you don't actually need those quite complicated carve-outs, which also presented their own difficulties of interpretation. And I hope, therefore, the statute is, as I say, easier to understand now than the previous version.
I'd certainly agree in terms of structure. It's much more straightforward. I certainly used to wrestle with the previous provisions, and for that reason, it's quite hard to market them if to get your head around them. My final question is: often you might have a UK family court make a decision purport to vary a Bermuda trust, or sometimes the trustees may seek to comply in part or entirely with those orders because they go through the process of properly considering the interests of the beneficiaries and making a trustee decision. This legislation doesn't prohibit trustees from doing that.
It doesn't, no. It is as strong as firewall legislation can possibly get, I would say, but it doesn't prohibit them from doing that. And what you've got to remember is firewall legislation isn't a complete protection when we are dealing with international structures, with assets around the world, and with settlors, normally settlors and beneficiaries around the world, then foreign courts are going to use their jurisdiction over foreign situs assets and over people located in those jurisdictions, the in personam jurisdiction, to give effect to those courts' orders. So if you have a Bermuda trust with whose principal asset underneath is a London property, and the UK court or the English court decides that that is a nuptial settlement which it's going to vary, there's not a lot the Bermuda court's going to be able to do about that. Similarly, if your settlor is a US citizen and the US court has made an order against him that unless certain steps be taken, he be committed to prison, then there's not a lot the Bermuda court is going to be able to do about that either. What this legislation does is it protects Bermuda trusts from overreach by foreign courts, I would say, in circumstances where they might exercise an exorbitant jurisdiction, but you've got to look at the facts on the ground. And sometimes it's in a trust's best interests for foreign orders to be complied with. And that isn't going to change under the new legislation.
Okay, thank you very much. I actually have some Russian dolls. I'll always use that analogy going forward.
Well, happily, you don't need them anymore to understand the Bermuda legislation. If you were having to understand the Cayman legislation still, then you would certainly keep those Russian dolls handy, and you can maybe label them with the various subsections to understand how they fit together.
All right. Thank you so much, Andrew. It's definitely been an informative session, and thanks for your time. And unless Business Bermuda Development Agency has any other final comments, I would just close the session, and thanks everyone for tuning in.
Thank you.
All the best.